Welcome to the American Museum of Tort Law. My name is Melissa Bird, and I am the director of the museum. The American Museum of Tort Law is located in Winsted, Connecticut, and is dedicated to educating the public about the concept of tort law and its role in American society. The museum features exhibits, artifacts, and interactive displays that explore various landmark tort cases and their impact on safety, justice, and corporate accountability in the United States. I'm delighted today to introduce our guest, attorney Pamela Gilbert of Cuneo, Gilbert, and LaDuca, who will be helping us untangle one of the most hotly debated issues in college sports, the future of name, image, and likeness, NIL rights for student athletes. At the center of the controversy is the Federal SCORE Act, a bill that supporters say will bring national consistency and fairness to college athletics, but which critics warn could strip away state protections, limit athletes' earning power, and shield the NCAA from accountability. Over the next 30 minutes, we'll dive into what's at stake for athletes, schools, and fans, and why this fight could shape the future of college sports for years to come. Welcome, Pamela.
Thank you, Melissa. Thank you so much. So I will just launch in. The National Collegiate Athletic Association, which is better known as the NCAA, its members, schools, and conferences are engaged in a multi-million-dollar lobbying effort to get Congress to pass legislation that would grant them unprecedented protection from the antitrust laws and from state laws. The bill that is moving through the House of Representatives is cleverly called the SCORE Act, which stands for the Student Compensation and Opportunity Through Rights and Endorsements Act. As an aside, I find it very often that folks on Capitol Hill have a real knack for coming up with clever names for very bad legislation, and the SCORE Act is one of them. To put the SCORE Act in context, let me give a little bit of background. The NCAA was founded in 1905 by the presidents of 62 colleges and universities to create a uniform set of rules to regulate intercollegiate football. Today, the association has over 1,000 member schools and regulates intercollegiate athletic competition in dozens of sports. The NCAA tightly controls the rules for intercollegiate athletics, including by establishing academic eligibility requirements for student athletes, setting forth guidelines for recruiting high school athletes, and imposing limits on the number and size of athletic scholarships that each school may provide. As college sports is a billion-dollar enterprise these days, the NCAA and its member schools bring in massive amounts of money each year due to the talent, skills, and hard work that are put in by the student athletes. The primary issue at play in the SCORE Act involves the NCAA rules relating to compensation for athletes, which historically has been stringently regulated by the association. There have been strict limits on athletic scholarships, grants in aid, and other education-related benefits. Until very recently, schools were completely barred from sharing any revenue with their athletes, and athletes similarly were completely barred from receiving any compensation for their name, image, and likeness. So name, image, and likeness, or its shorthand, which is NIL, is a very important concept to understand in this regard. NIL refers to a person's legal rights to control and profit from the commercial use of their name, physical appearance, and personal brand. The right is rooted in the right of publicity, which gives individuals control over how their identity is used for commercial purposes. Examples include for student athletes being paid to promote a product, being paid to appear on TV or at an event, being paid for their autographs, or being paid by a video company that uses the athlete's likeness in the game. And until very recently, the NCAA enforced extremely restrictive rules regarding athlete compensation that were unfair, unnecessary, and very harmful to student athletes. But because the NCAA controls who can compete in college sports, the athletes have no choice but to comply with the rules if they want to compete in intercollegiate athletics. So let me give you a couple of real-life examples about the harmful effects that the NCAA rules led to. So here's an example of Arian Foster, who's a former running back for the Houston Texans football team. But from 2005 to 2009, he attended the University of Tennessee and played on the football team in Division I of the NCAA. And if you don't know, Division I is the most competitive of the NCAA divisions, encompassing schools with the most robust athletic programs. So here's what Arian told the US Senate about his time as an NCAA athlete, and these are his words. When I was at Tennessee, there were plenty of times where throughout the month, I didn't have enough money for food. Our stadium has about 170,000 seats, 170,000 people buying a ticket to come and watch us play. I remember one game we had just won, and I had a good game, running about 100 yards or so. When I went outside after the game, there were hundreds of kids waiting in the tunnel. I was signing autographs, taking pictures. It was exciting and heady stuff. Then I walked back to the dorm and reality set in. I opened my fridge and there was nothing in there. I couldn't believe it. I didn't have anything to show for what I just did. I had no food, no money. I called my coach and told him we didn't have any food or money and we were hungry. So he came down and brought like 50 tacos for four or five of us. Believe it or not, him buying tacos for us was an NCAA violation, but he did it anyway. Another example is Ed O'Bannon, who actually became the lead plaintiff in a lawsuit that began the process of breaking the NCAA stranglehold on college athletes. Ed O'Bannon is a retired professional basketball player. From 1992 to 1995, he played Division I basketball for the UCLA Bruins. In 1995, the Bruins won the NCAA basketball tournament, and Ed was named the tournament most outstanding player. This is what Ed said in his testimony. When I was at UCLA, I would struggle at the end of the month just to make ends meet. And yet, I was a member of the first Bruins team in 20 years to win a national championship. The NCAA is still making money from that championship, but my teammates and I received no compensation while we were at school, and according to the NCAA rules, we were not allowed to share any of the profits for the rest of our lives. That is not right. So Ed filed a lawsuit against the NCAA when he found out after he had played that the NCAA was profiting from his college basketball career completely without his knowledge and without him being paid. Ed found out by happenstance. He was at a friend's house and his friend's son was playing a basketball video game. One of the players was a tall African-American man, left-handed, number 31. He was obviously modeled on Ed when Ed played college ball. At first, Ed thought that was pretty cool. But then he thought about it and realized that NCAA was making money using his image, and he was not able to share in any of that compensation. His likeness was being sold well after his playing days without his permission and without any compensation to him. If he was in any other walk of life, he would have had a right to share in that profit. But because he was a college athlete operating under NCAA rules, he was not able to receive any compensation for the use of his likeness. So he filed a lawsuit. O'Bannon versus the NCAA was decided by the Ninth Circuit Court of Appeals in 2015. While the students did not achieve the result they were seeking, which was to nullify the NCAA's rules prohibiting athletes from receiving NIL compensation, the case is significant because the court found that the NCAA was indeed subject to the antitrust laws, and some of its restrictions on athlete compensation were in violation of those laws. In response to the O'Bannon case, the NCAA had to loosen its restrictions on how much colleges could award in scholarship money to student athletes. It was the beginning of the courts finally holding the NCAA accountable for its actions. This accountability was then firmly established in the landmark Supreme Court ruling in a case called Alston versus the NCAA that calls into question the validity of all the NCAA's restrictions on athlete compensation. In a 2021 unanimous decision, the Supreme Court in Alston described the NCAA's action as, and I quote, involving admitted horizontal price fixing in a market where the defendants exercise monopoly control, where the NCAA was asking for immunity from the normal operation of the antitrust laws. The court ruled that the NCAA was violating the antitrust laws by placing limits on certain types of compensation. The best part of the Alston decision actually came from a concurring decision that was authored by Justice Kavanaugh, who's not usually a hero for the people, but he was really a shining light for the athletes in this instance. And Justice Kavanaugh wrote in his opinion, and it's one of my favorite quotes, he wrote, quote, "Nowhere else in America can businesses get away with agreeing not to pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate. And under ordinary principles of antitrust laws, it is not evident why college sports should be any different. The NCAA is not above the law." Justice Kavanaugh's concurrence went beyond the court's ruling and called into question the validity of all the NCAA's compensation rules, not just the ones at issue in Alston. The NCAA responded to Alston by suspending its rules prohibiting NIL deals to athletes from third parties, which caused a welcome sea change in compensation for college athletes, who could finally, after decades and decades, begin to share in the wealth they were creating for others through their athletic prowess. The court's ruling also led to many more lawsuits challenging the many rules and policies the NCAA had used to suppress college athletes' earning for decades. So the final group of lawsuits were consolidated under the name House v. NCAA, and they were settled recently. The House settlement completely restructured how athletes are compensated, how student athletes are compensated. For the first time, schools are permitted to share the revenue they receive from college sports directly with the student athletes. That had not been done before. In addition, the settlement requires the schools to distribute billions of dollars in back pay to student athletes who were denied fair compensation when they played for their schools in the past. These lawsuits that led to long overdue compensation and accountability for the NCAA brings us to the current onslaught that the NCAA has on Capitol Hill. For decades, the NCAA was able to enforce its unreasonable and harmful restrictions on college athletes, all the while making billions of dollars from those athletes' talents and hard work by claiming those restrictions were not prohibited by the antitrust laws. The Supreme Court finally put a stop to that in the Alston decision, and the NCAA has been forced to relax the restrictions and allow student athletes to function in the marketplace just like everybody else can function, including other students, just as we've always been permitted to do. So these changes have necessarily required the NCAA and its member schools and conferences to share in the wealth and drastically change their operations. So not surprisingly, the NCAA doesn't like this one bit. And they've gone to Capitol Hill in a multi-million-dollar lobbying campaign to immunize themselves from the antitrust laws and recently enacted state laws, so they will never again be forced to make changes to protect student athletes. They want to go back to the good old days where there were no guardrails on the rules they created and enforced. And hence we have the SCORE Act, which we expect, unfortunately, to be on the floor of the House of Representatives very shortly. So I'm going to go through some of the provisions of the SCORE Act that are most objectionable.
Oh, great.
So what I've explained, but I'll go into a little more detail, the bill would give the NCAA what it has been seeking for decades: immunity from the very laws that held them accountable for their abusive behavior. The SCORE Act's antitrust exemption would immunize NCAA and its member schools from legal accountability when it uses its power to cap athlete earnings, block transfers, or impose other anti-competitive restrictions. In doing so, the bill creates the conditions for the power brokers of college athletics to reassert dominance at the expense of athletes, and it robs college athletes of the ability to protect their rights. In fact, the bill does not include any enforcement mechanisms. It allows the athletic associations to create the rules and enforce them, the very definition of the fox guarding the henhouse. The SCORE Act gives power to the NCAA, universities, and intercollegiate conferences to limit the ability of student athletes to enter NIL agreements. The bill will now allow the NCAA to restrict the rights of student athletes in ways that would be flatly illegal in almost any other industry in America. So while purporting to grant students NIL rights, and there is a provision in the bill that allows students to collect NIL rights, it also includes exceptions. And the exceptions in the bill risk swallowing up the rule. So for example, the bill's exceptions allow the schools to limit student athletes from entering NIL deals if the deals would violate the institution's code of conduct. And those codes of conduct can be created and unilaterally modified at the school's discretion. So the bill says you have to allow NIL, but the schools can take away that right in their code of conduct that they alone control. So for example, an institution could use a code of conduct to limit the use of school apparel in student NIL agreements. That would greatly limit the NIL rights. And there's another exception, and that exception allows institutions to limit NIL agreements if they conflict with one of the school's contracts or agreements. So the school could make an agreement with an apparel company, for example, and if it made that an agreement with an apparel company, it could limit the right of a student to have an NIL agreement with a competing apparel company. The SCORE Act also provides data collection that could enable the schools to suppress the athletes' wages or compensation. So the bill explicitly permits schools to collect and share, quote, aggregated and anonymized data related to name, image, and likeness agreements. So this would create a breeding ground for algorithms that the NIL collectives and advertisers could use to suppress athlete compensation. Those kinds of algorithms are being used now in the rental marketplace. They're also used in various agriculture marketplaces, and they can be very, very problematic and allow price fixing. The SCORE Act also specifically prohibits universities from treating college athletes as employees. So the question of whether college athletes are employees is an issue that is currently making its way through the courts. And in fact, a decision from the Third Circuit Court of Appeals last year said that the NCAA cannot use quote unquote amateurism as an excuse for denying athletes employment status. So at best, it's premature for Congress to put the possibility of employment status or collective bargaining rights out of reach of college athletes forevermore in legislation now, when that issue still has not been decided by the courts. The SCORE Act would also provide sweeping preemption of state law for NIL and things beyond NIL. So the SCORE Act eliminates student athletes' rights to challenge a school or association's actions for noncompliance with the SCORE Act itself. There is no provision for student enforcement of the Act. And there's also broad preemption of any state law that quote unquote conflicts with the Act, which would eliminate the only source of a remedy for wrong student athletes. And the bill goes even beyond this. So the bill preempts states from enforcing any law, rule, regulation, requirement, standard, or other provision that conflicts with the Act. possibly eliminating student athletes' ability to protect their legal rights related to a wide swath of issues beyond NIL. For example, issues that include medical care for on-the-field injuries, school nutrition programs, sexual violence prevention, and mental health support. This sweeping broad preemption could even block future lawsuits to protect student athletes who are survivors of sexual violence. The bill requires institutions to provide comprehensive support and counseling related to sexual violence prevention, which is good. But because it requires institutions to do that, the students could not bring a state-based lawsuit over sexual violence prevention if the school's programs were inadequate because of the sweeping preemption provision. And finally, the SCORE Act creates a false choice between collusion and chaos. So some people do claim that the recent upheaval in the NCAA rules has caused chaos in college sports to the detriment of student athletes. And that's why they are calling for legislation by Congress. But even if that's true, Congress should pass legislation that respects the dignity of athletes without eviscerating their rights or giving a blank check to the NCAA power brokers, as this bill would do. Instead of giving a get-out-of-jail-free card to the NCAA through this bill, Congress should pass legislation instead to ensure that student athletes can enforce their rights when they are abused, exploited, or treated unfairly, just like everybody else can.
Thank you, Pamela, for walking us through that. I have a couple questions that I think you touched upon, and I just thought I'd see what you thought about a few of them. If the Congress does grant the NCAA this kind of immunity, does this set a precedent that could affect other industries? And could we see more powerful organizations then asking for special protections against lawsuits?
So that's a great question, and absolutely yes. This, for the most part, antitrust exemptions are frowned upon. And it doesn't matter, conservative, liberal, Republican, Democratic, we pretty much don't like antitrust exemptions in America because antitrust laws, which have been around for over 100 years, have really been the bedrock of our economy. There's only one sort of, sports association that has an antitrust exemption, and it's Major League Baseball. And it wasn't enacted by Congress. It's a judge-made rule. The Supreme Court came up with this some years ago, and it's really frowned upon, this baseball antitrust exemption. And again, anybody, baseball fans don't like it. Baseball players don't like it. Of course, the owners like it.
Yep.
And once you have an antitrust exemption, it's very, very hard to overturn. The Major League Baseball exemption is a good example. And so, yeah, if Congress now, after you have a unanimous Supreme Court decision from this Supreme Court, which is quite conservative, rejecting any kind of antitrust exemption for the NCAA, and then if you have Congress come back in and say, no, we think they deserve an antitrust exemption, yes, I fear that that would send a strong message to other strong and powerful collusive industries. They would love an antitrust exemption to come back to Congress and ask for it. And they'd say, like, well, if they could get it, why not us?
Yeah, that's right. So then if the SCORE Act went through, then who do you think benefits the most from this? Do you think it's the NCAA, the wealthy donors, the corporate sponsors? Where does that leave the athletes in the power structure, I guess is my question.
Sure. And, where it leaves them where they were before the 2021 Alston decision, and even, before the O'Bannon decision. And I think you heard those examples. These are, the myth is that, in order to go, if you're a great student athlete and you get a scholarship to college, you have it made in the shade. They're paying for your school, they're paying for your room and board, and you're doing great. But you saw those real life examples, and they're just two of, thousands, where these students, they got some athletic scholarships, but because of the NCAA rules, It were very, very limited, way more limited than any other student and in their ability to get a scholarship or help from the institution or outside the institution. They couldn't afford enough, they didn't have enough money for food at the end of the month. And this was the result of the NCAA making the rules, enforcing the rules, and no accountability outside of that. And that's what the SCORE Act does. So the SCORE Act, believe it or not, doesn't even have so it doesn't have a private right of action so the student athletes could go to court to say you're violating the rules. It doesn't allow any federal or state agency or state attorney general or Justice Department also to enforce it. There's no enforcement. So it allows the NCAA and the schools to make the rules, and then who enforces it? They enforce it, which is the bad old days. That's how it used to be. So who will most benefit are the NCAA, their member schools, and then the conferences, which are kind of mini NCAAs that run, the athletic competitions within their conference. And what it will allow them to do, like they used to be able to do, no court oversight. They create the rules, they run the programs, and they keep all the money.
So now, would that encroach on states or schools that weren't doing those things? Maybe they've come up with different structures, with the athletes that are benefiting the athletes right now. I mean, I can think of some schools that maybe don't follow some of these practices. So if this is passed, those schools then
are in jeopardy. That's exactly
okay.
right. Because the way the enforcement mechanism the NCAA has used is if you violate the rules, you can't be part of our athletic competitions. And they are the athletic competitions, right? Except for like club sports. But if you want to do intercollegiate official competitions, these are run by the NCAA and the conferences. So if you're like a rebel school that wants to do things differently, and the NCAA again comes in and says no more competition, no more antitrust rules, so you can't compete. We get to put all the rules in place and enforce them. Then a school is going to be forced, if they want to be part of the NCAA competitions, right, they're going to be forced to adhere to those rules.
You mentioned the ban on athletes being classified as employees. What do you see as the longer term implications of locking athletes out of labor protections? And could this affect how we think about labor rights for other groups?
Sure. So that's another, great question. When was the last time Congress took a whole group of people who are working and said, no matter what, you're not allowed to have a labor union or a collective bargain? And, there are a lot of issues out there in college sports. There's a lot of issues about their medical care, about the dangers of these sports, about Title IX and, gender discrimination, sexual violence issues. So there are issues that need to be addressed. And I'm sorry, as I was talking, I just lost my train of thought. So remind me of your question.
I was just
the collective bargaining.
Oh, yeah.
And a lot of these issues are, a lot of people think that could be resolved if these athletes were allowed to collective bargain, right? If they were allowed to get together as a group. And that doesn't necessarily mean they would have all the rights of employees, because we understand that they are students and they aren't exactly equivalent to, like a teacher who would be an employee of a college. It's a different status. So maybe there should be some hybrid that wasn't complete employment status, but would enable them to have collective bargaining rights, so they could bargain not only over compensation, but of other, workplace conditions as employees are able to. But if, a law is a law, so Congress passes the law, and this bill does not have any kind of sunset provision, so this would be the law of the land forevermore. no employee rights, no collective bargaining rights, which really would put these students at a great disadvantage.
Well, I think this is probably more of a comment, but I was looking into what the European Union does with this thing, and apparently this is like a uniquely American problem, as many many things are, uh, because in Europe athletes can professionalize earlier, and they are able to sign endorsement deals, and then when they are in school, one really doesn't have anything to do with another because they're playing on completely different fields. Um, it, I suppose we're too, it's not we're not going to change anytime in the near future to any of these things, but it does just seem strange to me that we have these kind of conflicts or these things that aren't issues anywhere else.
Right. And they're not issues for other students, right? There are plenty of students who are in bands, they act, do art, and they're able to make money from those things. I'll just add, one rule of the NCAA that is still in place despite all these lawsuits. You can't earn prize money in your sport outside of school and then go to school and compete in the NCAA. Like for tennis players, the limit is $10,000. So if you are a junior, and you're competing in the U.S. Open, which is going on right now, and you win prize money over $10,000, you have to give it back, or then you can't compete in the NCAA athletic competitions when you go to school. And there is no reason in the world for what is the point of that?
Yeah, like what?
What is the point of that? So of course around the world they wouldn't do that. It doesn't make
Yeah.
any sense, but it's just these restrictions that they've been allowed to do, so they do. And the more you allow, them to do it, I'm so struck by the fact that the NCAA has been such a bad actor for like 100 years or more. And this is the entity that we think we want to give a get out of jail free card from the laws that everybody else has to comply with. Doesn't make any sense.
No. Okay, well, I think we can wrap up. I want to thank you so much for taking the time to provide insight into this issue. It's clear future college sports isn't just about games, it's about fairness and protecting the rights of young student athletes. And I want to thank everyone for tuning in today.
Thanks,
All right.
Melissa.
Thanks
Bye.
so much, Pamela. All right, thanks again.